Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today I'm going to tell you a story, and it's a war story. You know the difference between a fairy tale and a war story, right? A fairy tale starts off once upon a time, and a war story starts off, you're not going to believe this, but, well, you may not believe this, but several years ago, I litigated a False Claims Act case, sometimes called a qui tam case, against a power company that will henceforth remain unnamed in this little ditty here. And I'm doing that because people associated with both the power company and the entity, the government entity, the Government Services Administration, are still around and still in active government service. And there's no reason to embarrass them more than they probably already are embarrassed by their own failures in this case. So we start with the idea that in the winter, the heating for the building, this is a federal building, heat was provided by a power plant. A coal-fired power plant near where this federal building was had leftover steam. After it was used to generate the electricity, you still have a lot of hot air going through those pipes, and they would pipe that hot air, that hot steam that was no longer able to generate electricity because its pressure had already been let off. They sent it down the pipe underneath a particular river and into this federal building. And so to make this easy to understand, the federal government was buying this steam for about, on the average, about $50 a day. And along came the electric power company. And the electric power company decided that they could sell the Government Services Administration a set of equipment that could boil water and produce steam, and they promised the government they would give them an extra low rate to make it affordable. All the government had to do was pay the $6 million up front to install these two boilers. So the government happily paid the $6 million to install the government boilers. And almost immediately, problems began. And among the problems that began were the fact that the steam boilers would frequently quit. They also required a lot more energy than the power company had said that they would require. And then in the middle of all of this, the rate that they promised they would give the Government Services Administration, the regulatory body over that power company said, no, you can't do that. That violates the restrictions that we have in place on public utilities. You can't give them that rate. You have to charge them the full rate you charge every other commercial entity. So now, instead of buying steam that powered the building or heated the building for $50 a day, they are now buying electricity for about $400 a day that is still heating the building, but at a greatly increased cost. And at the end of the day, after all of this, they went back to the way they were doing it before and just bought the steam. But the interesting part for our case was how they got this deal approved through the GSA. They held golf tournaments, and wouldn't you know it, the people who played golf in those golf tournaments won TVs. So one of the many things that people won in these golf tournaments, in addition to new plasma screen TVs and LCD TVs and golf clubs and certain 3-day trips, that sort of thing. In addition to those, they handed out sports tickets. Not any ordinary tickets. In this particular locale, there were a couple of sports teams that did really well during those years, and they became a hot ticket to get. They were hard. It was hard to get in at any of the stadiums in town because the teams were doing so well. And as a result, this particular company, power company, had a corporate box, and they would simply invite the people that they wanted to impress up to the corporate box, where in addition to serving free food and free alcohol, beer, mixed drinks, you name it, they would also sort of chat a little bit about all the great things this company could do for you. And that was just another one of the little perks that they handed out to the people from the government, and that the people from the government accepted. And by the way, we provided copies of some of the tickets. I know that in business, many times people use corporate boxes to do business. There's nothing inherently wrong with that, and there's certainly nothing inherently wrong with a corporate client or corporate individual taking somebody from the Government Services Administration to a football game or a baseball game at any other time of the year. But when you are in the middle of negotiating for a purchase, that's when it tends to look like maybe you're not playing square. Maybe you're not playing right with the government here in terms of treating these people the way you would treat them at any other time of the year. Again, no problem with the entire concept of rewarding people, particularly people you're doing business with, as long as I'm not paying them. I don't have a problem with it as long as I'm not paying their salary, because when I'm paying their salary as a taxpayer, I expect them to be working for me, not schmoozing with you. So I just wanted to make that clear in all of this. I think that's probably something that I may not have made a clear point of when I initially did this. This was a pretty big deal. And wouldn't you know it, the people who won the tickets tended to be high up in the organization and decision makers. Not the ultimate decision maker, I guess, but certainly people who could influence the decision-making process. And wink, wink, nod, nod, this was not a bribe because these people won these prizes fair and square. Yeah, that's kind of what I thought. Anyway, we made all of these allegations and we took it to the government. Now, when you file a False Claims Act case, the government gets the opportunity to determine whether or not to intervene. In other words, basically, it's like handing somebody a cherry pie. And then they take the cherry pie and they take their cut out of it and they cut you a little slice and give you back a reward. But if the government's not interested in the case, they can say, I don't want your pie. I'll take some money when you're done, but I don't want your pie. And that's what the government did. The investigator for the Government Services Administration couldn't find anything wrong. And amazingly, he couldn't find anyone who would testify that they had been bribed. Who would have thought? So, what happened? Well, we decided that we would take that case on ourselves as the government rules and the statute permitted. And with myself and another lawyer, we conducted a bunch of depositions. We briefed the issues. And at the end of the day, after multiple motions to dismiss and a failed motion for summary judgment, they filed another motion to dismiss on the basis of the public disclosure bar, which is a part of the qui tam statute that essentially says that if it was revealed by the news media or in a government report, well, then the government already knew about the fraud and you can't file this case. So the way they got to that was because the Public Service Commission in that state that regulated the utilities had issued a ruling against the defendant. Now, they didn't cite any of the facts that we cited, but they issued a ruling saying you can no longer grant this rate. And this was sort of a key thing because it happened before they sold the boilers and stuff to the federal government. And because that part of the claim was based on that prior ruling, which again didn't provide any evidence of fraud or misconduct, it just said this is the rule. The district court was considering whether or not to dismiss this on the basis of the public disclosure bar. We went to the government and said, hey, you have the right as the government to come in and say, don't dismiss this case, let it go forward. And the government said, no, I don't think so. No, we don't see anything really valuable in this case. You guys go have a nice day. So the case was dismissed. We took it up on appeal to the Eighth Circuit. And sadly, the Eighth Circuit hates False Claims Act cases. I think there's probably been 2 in the last 15 years where a relator prevailed at a relator is somebody who files that lawsuit, where a relator actually prevailed at the Eighth Circuit. But for whatever reason, in this particular case, they decided that no, that was a legitimate thing for False Claims Act cases. The public disclosure bar absolutely barred it, and there was just no recourse. Well, again, what's funny is after talking about how they stupidly spent $6 million, they bought these boilers, which turned out never to work. They clearly had a contract claim if they had wanted to file it. They didn't file it. Basically, the reason they didn't file it, in my opinion, is because the fix was in. The people that sold this and the people that bought this did not want to have egg on their face. So this $6 million boondoggle was swept under the rug. They pulled the boilers out. They put the old steam back in. And finally, somebody at least did something reasonably smart to even the scales. But this is how your government works. Anytime you give government employees the option to do their job, as the False Claims Act case does, it doesn't mean they're going to do the job. It doesn't mean they're going to be interested in doing their job. Because here's the thing, while we were going to be paid only if we were successful, the U.S. attorneys and the federal investigators who investigated our claim, they get a paycheck every month, whether they do anything or whether they do nothing. And that is at the core of what's wrong with our system. Now, none of these people, none of the U.S. attorneys, none of the people at the Government Services Administration in this, none of them are bad people. They're humans. They can make mistakes just as easily as anyone else. And in my opinion, that's what they did here. They made some fairly significant mistakes. That doesn't make them evil, and it doesn't make them necessarily the recipient of a bribe, although pretty clearly the federal acquisition regulations clearly forbid the kind of conduct that the power company engaged in and that the Government Services Agency definitely partook in. So because the rules made it unlawful, it should have been a slam dunk. The government should have gotten involved. They should have done the right thing. And if necessary, they should have cleaned house. But they didn't. So remember that when the next time you see government accounting error says we sent $6 billion worth of equipment to Ukraine that we really didn't send, or that we said we sent $3 billion and we actually sent $6 billion. That's because the government is made up of people, and the people make mistakes, and sometimes they make mistakes that are in their best interests. Whether they intend to profit or not is immaterial. They make mistakes that are in their best interest, and that always works against your best interest. So, as sad as it is, that's what I have to tell you today. That's my war story. Hard to believe that a government would do that kind of thing, just blithely wave away claims of abject fraud. But they did. And I have to say this much. The power company was represented by some really successful, very good lawyers, or very competent lawyers. And I don't hold any animus toward them for what they did. I mean, I felt like they kind of cheated by virtue of holding that till the end and using it as a Hail Mary pass right before we were getting ready to go to trial. That kind of ticked me off. But at the end of the day, they did what defense attorneys do. They defended their client. And ultimately, they defended them successfully. And this is also kind of funny. The company, the power company, was able to write off those attorney's fees as a business expense because they were successful. If they had not been successful, they wouldn't have been able to write off those attorney's fees. But because they were successful, they could. Again, that's what I have for you today. Hopefully you've enjoyed this, and let me know if this is the kind of thing you'd like to hear more about. As they used to say on an old TV program called The Naked City, there are a million stories in the Naked City. Well, there are a million stories in the law, and I probably don't have all of them, but I have a few to tell. Let me know what you think. Each of us has a role to play in our community with regard to things like racism and sexism. And when you see behavior that demeans someone, you should speak out. I wouldn't want you to put yourself at risk physically, but you should speak out. You should rebuke someone who refers to someone in a negative manner or with a slur, particularly a racial slur. There are some really ugly names that people use for women when they think they're among friends. And the only reason they continue to do that is because we make it acceptable by not saying anything. Think about that the next time you hear somebody that sets your teeth on edge with a racial or ethnic slur or by referring to a woman in an unpleasant way. Think about doing something about it. Not physically, but say something. If you hear something, say something. That's what I have for you. Thanks so much for watching. Catch me down here at the beach next time. If you liked this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.